Honourable Adam Searle.
Mr Assistant President, I lead for the opposition on the Independent Commission Against Corruption Amendment Bill 2016. I say at the outset we'll be opposing this appalling legislation, and I foreshadow we'll be moving amendments in the committee stage. There are two significant flaws in the legislation. The first flaw, which is fatal to the opposition's support for the legislation, and unfortunately we think is potentially fatal to the effectiveness of the institution of the ICAC, is the dismissal of the current ICAC Commissioner, which is what passage of this legislation will affect. And that's a theme to which I will return. The second flaw is the provision that requires merely consultation with the Chief Commissioner in relation to the appointment of the other two commissioners rather than concurrence. This stands in complete contrast with the model put forward by this government and adopted by this Parliament in the Law Enforcement Conduct Commission legislation recently enacted. And the government has given no reason or rationale as to why the three-commissioner model with those safeguards is appropriate for the LECC, but is not appropriate for the Independent Commission Against Corruption, and that is very worrying. Now, I note at the outset the Leader of the Government in this place and the Premier in the other place attempted to set out this stall about how pro-ICAC they are and how they really are in favour of an effective corruption-fighting body. But unfortunately, Mr Assistant President, trying to put it neutrally, they speak with forked tongue, because nothing is guaranteed to undermine not only the effectiveness of the institution but also public confidence in it, as the measures contained in this bill. Now, as is also traversed by the Premier and the Minister, many aspects of the bill find their genesis in the October 2016 report on the Joint Parliamentary Committee on the Independent Commission Against Corruption, handed down in October 2016. And as other speakers will no doubt go to, initially the chair of that committee and a number of the ideas referred to the committee were quite frankly harebrained and dangerous. But there was, because of the history of bipartisanship offered to government not only by the Labor Party, both when it was in opposition in the 1990s and now, but there has been efforts in the past by major parties to try and be bipartisan around issues to do with the ICAC. And so the opposition members of this committee, of whom I was not one, did work very diligently to achieve a cross-party consensus. And the basic new structure proposed for the ICAC, a three-commissioner model, is not opposed by the Labor opposition. And there are a number of views reached by the parliamentary committee which the Labor opposition members did support. For example, that the ICAC staff should not be brought under the government sector employment framework because that could compromise the operational integrity of the institution. That there should be no exoneration protocol and no merits review of ICAC findings because that fundamentally confuses the role of ICAC compared to law enforcement and criminal law enforcement bodies in particular. And these were matters that have been pushed by right-wing members of the Liberal Party and, of course, elements of the media as things that are vital to civilise the ICAC. And the committee very sensibly did not embrace those measures, and they're not in this bill, and that is a good thing. The committee also found that ICAC must follow the rules of procedural fairness during public inquiries and before publishing adverse findings against a person. And of course, lawyers will tell you that of course that already applies to the Independent Commission Against Corruption, but to the extent that it's worth spelling out more explicitly in the legislation, we certainly do not oppose doing so. And there are measures, for example, page 6, item 10, the new proposed section 79 capital A. There are elements lifted from the committee report, again, with which we do not take issue. In relation to issuing procedural guidelines relating to public inquiries, again, to promote better, more fairness, again, we don't oppose those measures either in the committee report or in the legislation. Of course, the bar rules that apply to barristers who, of course, are counsel assisting the ICAC are already bound to do those things. So, strictly speaking, we don't think there's a legislative need, but nevertheless, for more abundant caution, if the government wishes to spell that out in legislation, we do not oppose those measures. And so all the ingredients for an uncontroversial cross-party consensus about changing the ICAC structure, implementing a range of measures designed to promote public confidence in the institution and to enhance its operations, were all there. The seeds were planted in the committee report. The elements are all in the legislation before the House. But of course, this government just couldn't help itself. Still smarting from the findings in Operation Spicer, the venality and the spite that infects the right wing of the Liberal Party has led to the inclusion in this legislation of provisions that strike at the integrity of the body and its independence and its future effectiveness. And that is two provisions, which I'll briefly turn to. In Schedule 1, Item 4, it's the omission of the existing Part 2 of the ICAC legislation and the replacement with a new Part 2. That is the abolition of the current office of Commissioner and the replacement with the new office of Chief Commissioner and two other commissioners to be appointed by the Governor. And what that does is it actually bypasses mechanisms that are already in the legislation that enables Parliament to remove an ICAC Commissioner. I'll come back to that, but Parliament, when enacting the ICAC legislation, wanted to give the Commissioner the same independence as a judicial officer, and provided that during the period of time, up to 5 years, that an ICAC Commissioner would hold office, they would have the same protections as a judge and could only be removed by the Governor after an address by each House of the Parliament. And that was designed to make sure that executive government, whose workings would of course be the subject of the ICAC's scrutiny, and that scrutiny would often be uncomfortable and painful, it was to make sure that venal governments finding the operation of the ICAC inconvenient or politically dangerous didn't try to just remove the Commissioner. But to do so, of course, to make the case in the Parliament, you'd have to come armed with chapter and verse of the wrongdoings of the Commissioner. You would have to make the case both here and in the other place and in the court of public opinion that the Commissioner had somehow misconducted him or herself in office and had done things that were wrong and or improper. And of course, the government does not come to this Parliament prepared to make that case, because there is no such case to be made. Instead, the government takes the extremely dishonest approach of saying, well, we're just doing a restructure, we're just abolishing the office. And of course, at a stroke, if enacted, these provisions would simply throw the current Commissioner out of office, even though she was the appointee of this government, of Premier O'Farrell, and her term of office runs until January 2019. So, Mr Assistant President, this government will get to appoint the next ICAC Commissioner no matter what happens to this legislation. But they just can't wait, because they're still reeling and smarting from the fact that she has simply done her job. Now, you don't have to like what independent statutory officers do. No government, I'm sure, really likes what the Auditor-General does. I'm sure governments at times have found the operations of the Ombudsman to be difficult or inconvenient, and of course the ICAC. But this government has achieved a new low in seeking to take this route to remove a thorn from its side. an ICAC commissioner who was vigorous and fearless in pursuing her statutory duty as she sees it. Now, of course, if the government was serious, if they were serious about wanting to make the case that somehow she had done something wrong, they would come in through the front door. Instead, dishonestly, they're simply to hide, in the guise of a restructure, their true motivations. To pander to the extreme right-wing elements of the Liberal Party, many of whose members have lost their seats in Parliament and their careers in the ministry as a result, and to pander to the extreme elements of the Murdoch press who have been baying for the blood of ICAC for the last 5 years. And of course they can't get over the fact that the ICAC is their creation, but because successive commissioners have simply sought to do their job, they have exposed wrongdoing in the Liberal Party and by Liberal Party members, not only individually, but as we saw in Spicer, at an administrative and systematic level, in terms of systematic rorting of the electoral laws. Systematic rorting of the electoral laws. Now the fact is that this government has sought this.
Dr. Phelps knows that interjections are disorderly. Would he allow the member to continue his speech on this very important bill?
Thank you, Mr. Assistant President. Now, the government did seek bipartisanship on the bill, and of course, as I have indicated, there are many aspects of the bill that could be the subject of bipartisan support. And of course, those of us on this side of the House did cooperate fully with the government in the wake of the High Court ruling of Caneen versus the ICAC. And we were very cognizant, as was the government, of the report by a former Chief Justice of the Supreme Court and of the High Court, the Honourable Murray Gleeson, and of course Bruce McClintock, Senior Counsel. And we cooperated with the government in the implementation of revised ICAC legislation, because we saw the importance not only of making sure the ICAC kept to the law, but it was appropriately configured to do its job. But as I indicated, the legislation now before us, with the sting in the tail of abolishing the office of Commissioner, is a tawdry and disgraceful exercise simply to sack the current Commissioner, and we will not be part of it. And the government is trying to sneak this legislation through at the fag end of the sitting year, and of course it is instructive that they've chosen this week. It was only on Saturday that the National Party received its worst electoral result in its safest seat. And it's a blow to the Conservative side of politics more generally. But rather than suggest that maybe we've been getting something wrong, maybe, as people have been suggesting, we've been high-handed and arrogant and out of touch, instead of being cognizant of the judgment of the community, particularly a community that has resolutely supported that side of politics since 1947, sending only country and National Party state MPs to this place. Instead, they've doubled down on their arrogance by bringing forward this measure and seeking to rush it through Parliament. The significance of this legislation is such that it should have let it sit on the table, should have engaged in broad-ranging consultation, as they did with the Law Enforcement Conduct Commission bill. Now, on that bill, whatever its shortcomings ultimately turn out to be, you couldn't fault the government for consultation. The opposition had 2 or 3 briefings on draft bills. There was extensive consultation with the Police Association, the Law Society, the Bar Association, and all the affected stakeholders or people who would have a view about these matters. But not this legislation, because this legislation is not about proper public administration. It's not about protecting or enhancing the ICAC. It's just about saying gotcha to the institution and gotcha to the Commissioner who has caused the government. No, we are not supporting this legislation. Let's be very clear about that. We cannot support it because of this government's overreach in seeking to throw out of office for no justifiable reason the existing Commissioner during her term of office. During her term of office. Now, the fact is that the ICAC has inquired into and reported on the activities of people in my party, and we don't shy from that. the difference between this side of the parliament and that side of the parliament is we don't seek to attack the law enforcement body. We don't say, well, you found members of our party to be corrupt and to have shortcomings in their conduct. We say, yeah, fair enough. We will try and lift our game. We will root these people out of our party. But what does that side of politics say? They attack the messenger. They seek to cut the head off of the body that has caused them so much grief ahead of the last election, has cost them so much public money and public funding, and to this day still causes grief because of the internal ructions within the Liberal Party that those findings by the ICAC have caused.
There's no ructions.
And let's just, and it's not just what we are saying about this legislation. Let's see what other ICAC commissioners have said. The former Commissioner David Ip said this legislation would weaken the ICAC and water down its powers, and seems designed to get rid of Ms Latham because she had been too independent. He says, and I quote, "I think it is a scandalous move. I don't accept for one moment it makes a stronger ICAC. I think it will be much weaker and will make it much more difficult to operate. There will be an inability for it to make quick, strong decisions, and there's simply no need for it. The ICAC has never been stronger." Now, a former Assistant Commissioner of the ICAC, a former judge, and in fact the current chair, I think, of Transparency International Australia, Anthony Wheely, has said the legislation would effectively sack the Commissioner in the middle of her tenure. And I quote, "It's absolutely stunning that this has happened, and there seems to be no justification for it whatsoever. I think it's very wrong and very harmful and should be very damaging to the Baird government." Now, of course, Mr Ip also said this has come about after 11 members of Parliament, pause there, Liberal members of Parliament, have been forced to resign, and after the Obeid inquiry and the Doyles Creek inquiry, when corruption involving many millions of dollars was uncovered. One can only see this, by which he means the legislation, as an attempt to protect politicians, an attempt to protect Liberal Party politicians, Mr Assistant President. That's the real agenda here. Now, of course, Mr Wheely, of course, noticed that the move in this legislation has followed ICAC's Operation Spicer investigation into Liberal Party fundraising before the 2011 state election, which ended the political careers of a number of Liberal MPs, and of course the ministerial career of at least one of our colleagues in this chamber. Now, the perception, says Mr Wheely, will arise immediately in the community's mind that there's a very direct link between the two. It will look like payback from a vengeful government. If we read about this in a third world country, a public inquiry into politicians behaving badly, donations being made illegally and secretly, a report published, and then the government brings forward legislation to get rid of the head of the organisation which published the report and tries to dilute the powers of that person, you'd say, well, same old, it's corrupt. I'm suggesting the perception in there that this is done to weaken ICAC's power and bring Megan Latham into line so that she doesn't step in and offend the politicians, he said. That's the perception, and it's a very bad perception. So we have two esteemed former judges, both closely associated with the ICAC in the past, not only the Labor opposition, saying this is a fundamental attack on the institution as well as on the person of the current Commissioner. And it's just not good enough. And of course the current Commissioner has also made a public statement. She put a blistering statement on the ICAC website in which she said, "The bill represents an unprecedented attack on the independence and effectiveness of the Commission as a leading anti-corruption agency." She went on to say, and I quote, "The most significant practical consequences of the provisions were not the subject of any discussion or submission before the ICAC Parliamentary Committee or in any other forum, and find no expression in the committee's report." And that's, of course, an important thing, because of all the many issues that were referred by the Premier to the Parliamentary Joint Committee on ICAC, and of all the hundreds and thousands of words expended in this report, not once was the issue of terminating the commission of the current ICAC Commissioner ever raised. It's not just that the report is silent on the matter, it was never put. Never put. And of course now the government's disingenuous, saying, well, yes, of course her position has to be terminated because there's a a restructure, but we'd welcome a reapplication by her. We'd welcome an application by her. Well, that's false. They wouldn't. The truth is, if the government was serious about her at least finishing her existing tenure, there would be a transitional provision in the legislation that simply makes her the Chief Commissioner to serve out the balance of her current term until January 2019. That's the effective and the appropriate course of action. And that is the course of action that we will be urging on this Parliament in amendments in the committee stage. That, Mr Assistant President, of course, is what we insist upon if the government is serious about bipartisanship. The ICAC Commissioner also says the bill should provide that the person holding office as the Commissioner immediately before the commencement of the amending legislation is taken to have been appointed for the balance of his or her term as Chief Commissioner, and that is what we think would be the fair and appropriate course of action. Because the tenure and independence of the current Commissioner, it's not about her, it's about the institution. Because if executive government are on the receiving end of painful and inconvenient news about scores of their political operatives in the Parliament and in their party administration, calling them into public question, public opprobrium, leading to their loss of careers. If the executive government can get away with simply cutting down the messenger, it will mean that future ICAC commissioners are likely to not do their job properly, because the consequences of doing so will be this kind of authoritarian intervention of the kind not usually seen outside of petty dictators in other parts of the world with which we would not usually want to associate ourselves. And this is not just our view. The Honourable Nick Greiner, the former Liberal Premier who himself was ultimately a victim of the ICAC, put it well in the second reading speech on the 26th of May 1988 in the other place. I quote, "I make it clear in my statements before the election that the proposed Independent Commission Against Corruption would be responsible to Parliament and not to the Executive Government. The Commission can be removed only by the Governor on address of both Houses of Parliament." It was Greiner's commitment when he created the body with the support of the Labor opposition that the Commissioner would have the authority, unimpeded by the politics of the day, to inquire into corruption wherever it occurred or allegations of corruption. And that has been the case, an article of faith in New South Wales politics for the past 28 years. Bob Carr gave unconditional support to Premier Greiner when he created the body. We have continued to do so during our term in opposition. But of course, it is this government and the actions of this government alone which are ending that cross-party consensus. On 30th of August this year, the ICAC reported on the Operation Spicer investigation, which exposed prohibited donations and the channelling of funds. The ICAC released the report. The report gave chapter and verse of prohibited donations, funds channelling, non-disclosure during the 2011 state election campaign. The ICAC's findings were adverse with regard to a significant number of Liberal Party members in finding that they acted with the intention of evading provisions of the Electoral Funding Expenditure and Disclosure Act relating to the disclosure of political donations and the ban on donations from property developers. The ICAC found that during November-December 2010, the Free Enterprise Foundation was used to channel donations to the Liberal Party for the 2011 state election campaign so that the true identity of the donors was disguised. A substantial portion of the money that was provided by the foundation and used by the Liberal Party in its election campaign originated from donors who were property developers and therefore prohibited donors, and of course the Premier resigned. The Electoral Commission reviewed the matters investigated by ICAC, and the Liberal Party's failure to disclose a series of political donations received by the party in 2010 and 2011 resulted in the Electoral Commission ruling the Liberal Party was ineligible to receive $4.4 million in public funding. After further disclosures from the Liberal Party in September 2016, the Commission decided that the party was eligible to receive $5.8 million in public funding, but it withheld almost $600,000 being the amount of the donations that the party had accepted illegally. ICAC's work cost the Liberal Party $600,000. It delayed the payment of millions of dollars and, as I said, ended the career of many Liberal members and parliamentarians. The only conclusion that one can fairly draw from this legislation, which terminates her term of office, is simply political payback. Now let's look at what the current Premier has actually said about these matters. The findings showed that the finance director of the Liberal Party, Simon McInnes, at the time was complicit in seeking to disguise payments from prohibited donors, that the party's fundraising body, the Millennium Forum, was used to launder banned donations, and of course the current Premier, when he took office in 2014, said that he was appalled by the things that had been seen in the ICAC proceedings. And of course he said, I don't care what political badge you have. If you have done wrong and if ICAC has shown you to have done wrong, then I'm your worst nightmare, quote unquote. Premier Ben.
Must be two of them.
But of course today, rather than standing up for a strong anti-corruption body, he is actively seeking to nobble it. And of course, Anthony Wheely and others have said that there's a strong perception that these actions by this government are corrupt. Because how else can you interpret the nobbling of the anti-corruption body by a government seeking to cover up actions of its party as being anything else? Simply payback. Payback. And that's what it was. And of course, we see the exposure of the rotten activities in the New South Wales Liberal Party, and this Premier simply seeks to take on the Commissioner and to terminate her position rather than to stand up to the corrupt elements of his own party. Well, either the government's corrupt or it simply lacks a spine to stand up to the corrupt elements in its own party. Whichever is the truth, it brings no credit to the Premier or his government, and they will be judged severely and found wanting in the court of public opinion. And of course, it's completely contrary to what the Premier said when he took office. But, of course, it is consistent with the inaction of the Premier, because, of course, in the wake of Spicer, the systematic rorting of electoral funding and disclosure laws by his MPs and party administration, because of the very small window in which those offences could be prosecuted, 2 years, all of those persons found to have done wrong all get off the hook. But when legislation went through this Parliament to provide not only for increased penalties, but longer timeframes for the enforcement body, the Electoral Commission, to actually bring them to justice, we said, look, a time period is not a substantive part of the law. It's simply a time to bring a prosecution. In the wake of Spicer, let's make those acts fall within that expanded time frame. If there is evidence to sustain a prosecution against these people, let them be brought to justice, as the Premier said they would when he took office in 2014. But the members opposite in this place and in the other place acted to let their buddies off the hook by making sure that the extended timeframes did not apply to their wrong conduct. Did not. It's not retrospective. A time period is not a substantive element of the law.
Extending a time period.
It's not a substantive part of the law. You acted to cover up for your mates in this place and in the other place.
Point of order.
And it's a low point.
Point of order.
It's a low point of public administration. It's a low point of public, and so is this attempt to silence the opposition on this matter.
Mr. Searle.
Mr. President, the honourable member said, and I quote, "You attempted to cover up for your mates." Given that all debate goes through the chair, that's a reflection on you, Mr. Assistant President. And it should be withdrawn.
Mr. Assistant President, I in no way intended to reflect upon yourself. I was reflecting instead on the members collectively on the government benches. So let that be very clear what is being said. What I was saying.
No point of order.
I was just responding to the point of order.
Collectively on the government, individually.
There is no point.
Yeah.
Thank you, Mr. Assistant President.
Individually. I thought it was.
Now the second flaw, so we simply cannot support legislation that seeks to turf out the current Commissioner mid-term for no stated reason, simply for doing her job. You mightn't like the job she's done, you might be critical, but if you're not prepared to actually bring a dismissal motion before the Parliament and set out exactly and in public what she has done that you disagree with, not whispering behind hands in meeting rooms in cabals in other parts of this building,
Liberal-
but
Liberal
in the
Party
light of day, being open and honest, level the charge against the Commissioner, set out chapter and verse what you say she's done wrong, and then have a vote. And then have a vote. And a vote of the kind that we've had in this place, Mr Assistant President, when the removal of judicial officers has come before this place. Not a party vote, a bound government versus opposition vote, but whenever the fate of judicial officers has come before this chamber, it's been a free vote of the members.
And how did you vote?
I voted to not dismiss those creditors. But the point being, it should be a free vote of the members. A free vote of the members of Parliament if you're serious about levelling charges against the Commission.
The interjections.
So the fact is,
and
this
interruptions.
government doesn't have the courage of its convictions, or at least doesn't wish to do so openly. It's hiding its true motives. It's malign, potentially corrupt, but certainly improper motives behind the rubric of a restructure. The second flaw, as we've indicated at the outset, relates to the issue of the concurrence of the Chief Commissioner in the appointment of the other commissioners. We were told the three-commissioner model was based upon a provision in the Law Enforcement Conduct Commission Bill. And of course, that legislation provides that commissioners can be appointed only with the concurrence, i.e. agreement, of the Chief Commissioner. But this legislation does not do that. It only requires consultation, not concurrence, which means this government wants to keep as a tool in its back pocket. If it doesn't like its Chief Commissioner, they can try and stack the cards against the Chief Commissioner by surrounding him or her with more suitable other commissioners that can overbear his or her will. So the fact is that is not proper, and it's not part of the original intention of the ICAC. If you look at page 675 of Hansard on the 26th of May 1988, the explanation presented by the Honourable Nick Greiner on the ICAC legislation said, the Commissioner will have total direction and control of the Commission. He or she can be appointed only for a term or terms totalling 5 years. It can be removed from office only by the Governor on address by both Houses of Parliament. This is one way in which the independence of the Commission from the Executive is safeguarded. But this legislation doesn't do that. And of course, another way in which it seeks to undermine that independence is by making sure that the Chief Commissioner is not in control. Of course, there's the Chief Executive to be appointed, but the more insidious element is the surrounding by other commissioners who are to be more compliant. Now, we think the simple answer to that is to reflect fully the LECC model. To simply say, yes, you can have the other two commissioners, you can divide the work up, but only with the concurrence of the Chief Commissioner. We do acknowledge that the original proposal that operations had to be conducted only by unanimous decision of the three commissioners, and that has been reduced so that it's only a majority rather than unanimous, and we acknowledge the government has taken on board the opposition's suggestion that the Chief Commissioner has to be part of the majority. That wasn't in the government's original draft, and it is a suggestion that they have taken on board from the opposition, but only, it seems, because their ultimate and true objective is to attack the current Commissioner. It seems to me and to the opposition that there is, as an inevitable conclusion, that government members are not pursuing the model outlined in this bill because they are supportive of the merits of the model. They are pursuing the model to achieve a particular outcome, and that is simply to remove the Honourable Megan Latham from office. That is an outcome, I think, that will do more damage to anti-corruption forces in this state than anything else I could think of. You cannot do this to the Commissioner during her term of office when no allegations of wrongdoing against her have been made without fatally injuring the ICAC. It's particularly appalling, I think, that the government does not have the integrity, transparency or courage to come here and to make the case openly, because they don't have a case. She has done nothing wrong. They simply disagree politically with what she has done and they want to get rid of her. And that is also why they're seeking to ram a bill of this significance through both of the Houses of Parliament in a little over 24 hours, because they simply want to make sure that they can strike while the iron is hot and hope that everyone forgets about it over the summer break. That is improper, and as I have said, It's not only an unprecedented attack on the ICAC by the Liberal government. It is hubris, it is arrogant, it is out of touch. But more than all of those things, it is dangerous because it gives encouragement to all those people wanting to do wrong in public administration of the state, whether politicians or otherwise, that if you're an ally of this government, they will intervene to protect themselves and to protect you. And that is simply not proper or appropriate. We do note, of course, that on having her office terminated, the Honourable Megan Latham will have her commission as a Supreme Court judge revived, and that is, of course, appropriate. But the whole point of the legislation is to try and quarantine the Liberal Party from ICAC and the consequences of their own wrongdoing. Well, I think this is perhaps the lowest point in the fight against corruption in New South Wales in public life in 28 years, and it's been brought to the chamber by Premier Baird and by the Baird government. And it really puts the mockers on what he said about being the worst enemy of corrupt elements when he took office in 2014. And those, whether in the community or the media, who took him at his word, will be deeply disappointed, not to say shattered. It's wrong as a matter of principle to simply attack the messenger because the message is inconvenient and has caused pain to the ruling party. We don't support the legislation unless the government comes to its senses and adopts our sensible and balanced amendments. I've also indicated in my second reading contribution that we don't think a legislation of this significance should be rammed through in just over 24 hours. We think there should have been much more consultation with the law bodies and with the wider community, as there was with the LECC bill. So, consequent on that view, Mr Assistant President, I move that the question before the House be amended by omitting now and inserting instead this day 6 months. Because I think that the community should have the opportunity to become fully aware of this legislation and to have its merits debated in the wider community, not quickly rammed through ahead of the summer break, and so the government hopes that everyone will forget about its appalling actions. Forgets about its appalling actions. Forgets about its appalling actions, and I think I will conclude on this point. I referred to the statement put up by the ICAC Commissioner, the Honourable Megan Latham, which of course is on the ICAC website, and I could read it all into the record, but I will read just this one bit. I will just read this one bit. The ICAC, and I quote, "The ICAC Act currently provides that a commissioner can only be removed on particular grounds, none of which apply in the present circumstances. The bill introduces a mechanism whereby any commissioner may be removed from office on the basis of amending legislation which purports to restructure the commission. The bill provides that upon commencement of the amending legislation, I would cease to hold office as commissioner. There is no justification for this, and none has been suggested. This is a significant matter that was not raised with the Commission by the Parliamentary Committee and has never been raised by the Premier." Quote unquote. This government simply doesn't like the job the Commissioner has done. We don't cavil with the right of executive government to come and say, let's restructure and improve the body. And as I've said, we are prepared to embrace, with some misgivings, that model because our members in the Parliamentary Committee worked very hard to achieve that cross-party consensus. But that's not the government's true objective, it's clear. Its true objective is to shoot the messenger, is to remove the Honourable Megan Latham from office simply because she interrupted the careers of 10 or 11 Liberal MPs and revealed to all to see the systematic rorting of the Liberal Party administration of the electoral funding and disclosure laws, and this is the brutal political payback. We earnestly ask the Parliament to not allow this to occur, because that would be bad not just for ICAC, not just bad in the fight against corruption, but would be such a low point, and members opposite should think very closely before associating their names with such measures for all time. We'll be proposing those amendments so that the government can be saved from itself, and even more, the community can be saved from the malice of the actions of this government.